Hello, everyone. This is Rob Fields. I want to thank you all for joining us for this PMA webinar. I'm really excited to talk about one of my favorite subjects, which is music. And specifically today, we're going to be talking about music licensing with Howie Weingrad, who is the partner in the Advertising, Marketing, and Promotions, Entertainment, and Media and Publishing Group at Davis & Gilbert. Really excited to have him here today. He has been ranked by Chambers USA as one of America's leading lawyers, making this the fourth consecutive year that he's been recognized. He spends a significant portion of his time and most of his practice is devoted to broadcast advertising production matters, negotiating and structuring agreements, governing the use of celebrity talent, and also with lots and lots of music licensing daring do. So without much more delay, I'm going to turn this over to Howard. Before I do that, though, I do want to point out that, yes, you are all in a kind of a listen-only mode, a lecture mode, as this system says, which means that I can't unmute you to talk or ask questions initially. If you think you're going to have some questions, I would certainly suggest that you should dial back in and listen in via the phone number that you were given in your confirmation letter. That will enable me to unmute you if in the event you have a question. We are going to handle questions via the chat function or the question box, so please feel free to throw a question in there. We will stop periodically to see if there are any questions about any of the material that Howie's covered thus far. If not, we'll continue. If there are questions, we will stop and answer them. And again, if you are listening via your phone, I can unmute you and you can sort of do follow-ups or ask your question directly to Howie. With that being said, I'm going to turn this over to Howie, and we're going to get started in talking about hot topics in music licensing for advertising. And here you go. And guys, if you just hit your show my screen button, you are ready to go.
Okay, thanks, Rob, and thanks for that very nice introduction. Hello, everybody. Thanks for logging on or tuning in or coming to whatever you're really doing to the webinar today. And as Rob says, I'm going to be addressing some hot issues in music licensing. From looking at the list, I can see that many of you know me and I know you, and we've dealt with each other throughout the years. And I've been handling the legal side of licensing music for advertising for, actually scares me to think of this, but close to 20 years now here. And I can tell you, and as many of you know, it's not as simple as it used to be. You know, when we started doing this years ago, or when I started doing this years ago, you know, not only was there less attention paid to various kind of collateral and ancillary rights that need to be obtained, because lawsuits and claims in these areas had yet to come up, but the media was limited too. So for the most part, we were dealing with licensing a commercial recording pretty much for use in television and radio commercials. And you know, throughout the years, a lot has changed. The changes have made it more difficult for you on the agency side and advertisers on the being concerned about protection to do your jobs. So the overall thread really running through these topics, I think, is to understand ahead of time that these issues exist or may surface, and to plan accordingly. And that's really the key, to allow enough time to resolve these issues before the ship sails with the music that may not be completely licensed. Because, as you know, once the commercial or other materials are out there in the marketplace, then, of course, whoever it is that's making the claim has great leverage to get what they want. And we've seen a lot of that in recent years with respect to not only copyright, sound-alike issues, and most importantly, I think, in terms of what's happening quite frequently now, are these Section 28 claims, which I'll get to. So, in terms of the basics here, I think most of you know this, but we're really dealing with three silos, okay, three buckets of rights. And I'll just go back to what I said earlier, because we initially only dealt with two buckets of rights. So the first two are, of course, the requirement of licensing the sound recording, which you want to use, and then the composition, which is embodied within the sound recording. Sound recording is owned by a record label, typically, and a publisher will own the underlying composition. It's this last source, this last bucket, that we're really going to be focusing on today, primarily, and that's the artist. I think that for many years the notion was, label handles all. Go to label, get your deal done, don't worry about anything else, get your proper warranties and reps and indemnities, and you should be good to go. So the master use license, that's what allows us to reproduce and use the sound recording within an audiovisual work such as the commercial. Just as a sort of sidebar to that, we are sometimes dealing with samples that might be incorporated into sound recordings, and we need to chase those rights too. And it's not always the case that the label will own those rights, or if they have a deal with the sample owner in terms of distribution, it still may be that we need to actually go directly to the owner of the sample to do that license. So it's important to note that, even if the label's been selling a record for 10, 20 years that has a sample in it, you still may need to go directly to the sample owner. I'm going to try to ask this periodically, but again, as Rob said, if you guys have any questions at any time, I don't know how you do this. I'm told you just kind of type it in, but just fire them in, and someone will let me know, and I'll answer the question. The next component is the sync license. Again, that's the license that involves the underlying composition that's embodied in the sound recording. In instances, of course, where that underlying composition is in the public domain, then we will not need to get that license. But if we're talking about an arrangement of a public domain song, then it may be that there is a separate copyright to that arrangement, and there may be a publisher that administrates that copyright, so we would have to get a license for the arrangement of the song that is otherwise, or that is in the public domain. And what is or isn't in the public domain, the answer to that question is not always so easy. It could be that something's public domain in the United States, which follows U.S. law, but it may not be in the public domain outside the country where the laws are different. And some of you on this list may have even been caught up in that trap, where we were led to believe that something was PD, and then we got a claim from a publisher in Europe where the laws are that typically that the work can last for a longer period of time. So that has to be all buttoned up. I'm not going to delve any more into that today, because that really is not what we're here to focus on.
Hey,
yeah.
Howie, we do have a quick question before you get too far along. Jessica would love for you to clarify what you mean by sample owner.
Okay, that's a good question, because there may be two owners of a sample. A sample, of course, is the use of a pre-existing or snippet or a portion of a pre-existing sound recording, which is embodied within the actual recording. So, the best example is in hip-hop or in pop songs, where instead of assembling musicians to actually create something, it may be desirable to use something that's recognizable as a pre-existing hook from from another work, and that would require the use of another sound recording. So basically look at it as a sound recording within a sound recording. So the same rights that you need for your primary sound recording, the recording license, the master use license, and the publishing license would be required for the sample. So the sample owner would be the record company or label that owns that sound recording that's being sampled, and then the publisher of the composition embodied in the sample that's being used. I hope that answers the question. Getting back to the PowerPoint here, if you'll see I've got something about cover recordings. This is important. If the recording that you want to use is a cover or a new version of an existing song, I mean, clearly there are songs out there that have been recorded multiple times, and it might be that we want to use a particular recording, which is not the first recording of the song. It might be something that, for whatever reasons, for creative reasons, is more desirable. We need to make sure that whatever synchronization license we're getting from the publisher supports essentially the sound recording that we're using. That will typically be the case. It is not often, that there's some cover version or arrangement of a pre-existing work that will require us to somehow go to another publisher. But in all my years of doing this, I actually had to do that once. The agency was using the Cowboy Junkies version of Blue Moon. And if you recall that song, there's a very distinctive introduction that the Cowboy Junkies created that was kind of, locked on in the beginning of the song. And because it wasn't really particularly derivative of or derived from the actual song, they were able to get a separate copyright in that introductory portion of the song. So it wouldn't have been enough to go to the publisher of Blue Moon, the old Elvis Presley song, or whoever actually sang that first, because when using the sound recording from the Cowboy Junkies, you were actually exploiting two underlying copyrights, one to Blue Moon and the other, which was an outgrowth of the new and sufficiently original introduction that the Cowboy Junkies did. So when in doubt, how do you figure that out? It's really best to have a musicologist weigh in as to whether or not any kind of arrangement or any kind of cover version or new sound recording or new version of a work has sufficiently new material in it that might be original, so you'd have to go to another publisher. I better get moving here, or else I'm not going to finish everything. But again, don't stop sending questions. If you have those, I think that's probably the most beneficial thing we can do is just turn this into question and answers. So keep supplying those. Okay, now let's get to the the silo, the bucket that has been causing the most problems for everyone, and that's the artist permission. Again, it's not the case that a record label will necessarily have everything you need with respect to that sound recording. Hold aside the sync license. You got your sync license in place, fine. You go to the label, you want to use the sound recording, and it's just not the case that no matter what they tell you in terms of whatever rights they have, that you're going to be okay. And that's because artist consent can really be bifurcated. You can think of it as a consent that is required based on really two sets of rights that are held by the artist. The first set would be the artist's personal rights, their rights of privacy or publicity, or their right to control the exploitation of their persona, which is really the right that the label will control. When the artist, back whenever, decided to record for a label, its agreement with the label will likely provide that everything is a work for hire, running from the artist to the label, and that the label controls the performance right and is able to sell records to the public at will, so long as it accounts to the artist for whatever amount it has to account for under whatever deal it made. More often than not, and this is particularly the case in later years, the label also has the right to commercially exploit the work, meaning that it will have the right to license the work for use in advertising, and it will not necessarily have to go back to the artist to get that consent. So this consent, this personal right of performance, this publicity right, this exploitation right, that is the consent that the label will have. I mean, if it doesn't, then you've got to go directly to the artist, clearly. But it is more often than not that this is the right that the label will have and will warrant and represent that it has. And I've got some examples in here of some language, but you know, for the most part, you need to make sure that these agreements include artist consent in the warrants and reps. But that's not the end of the story, unfortunately. And it's not the end of the story certainly with respect to any ad agency or producer or advertiser who is a signatory to the Screen Actors Guild commercials contract. Now we're talking about a separate bundle of rights that the artist has because the artist, when it recorded this record, and it's not every record, but let's just now assume that it's 95% of whatever is recorded in this country on most labels, and that is that the artist will typically have recorded under the AFTRA sound recording labor agreement, or the AFTRA phono code. For that reason, the label has taken on employer obligations. And one of those obligations that the label took on was to make sure that any quote-unquote new use of the sound recording. Now, what's a new use of the sound recording? It's not a use that the label makes in selling records. It's a new use that's not contemplated by the sound recording labor agreement, and it's a use that's typically made by a third party. That means us. That means it's a licensed use by an advertiser for use in advertising. It's also a licensed use for use in a movie or a TV show. But for these purposes, for what we're talking about today, this new use is an advertising use. That's the obligation of the sound recording company, or the label. Okay? Section 28 of the SAG commercials contract, which is a separate labor agreement, collective bargaining agreement that many agencies and advertisers are signatory to, requires that the signatory agency negotiate with any singer whose performance was made under the jurisdiction of the AFTRA phono code on a sound recording that they're using. So in the first instance, this is really connecting the dots, essentially, between the label's requirement to make sure that the artist is paid royalties for new uses, and this obligates the user under its own collective bargaining agreement to make those payments. Okay? Quite frankly, this is a pain in the butt. I mean, this is a huge encumbrance to the ability of the record label and the advertiser to freely do a deal with each other. Nobody wants to deal with this, and unfortunately, well, for many years, it just wasn't dealt with. The first claim that we became aware of here was back in '94 or '5 when the Ronettes brought a lawsuit against American Express for the use of "Be My Baby" in a commercial, and the agency had done their deal with the label, and the Ronettes, who were fighting with the label, had received no royalties for the vocal performance. And it took a lot of people by surprise, because while Section 28 had always been in the SAG contract, it was just one of these areas that nobody really was aware of, nor was it ever really enforced. Well, we quickly came up to speed on that. But there's been a great lag in the industry between lawyers knowing about it and agencies in practice dealing with it. So, by the way, Rob, any questions so far?
We had one just on the issue of consent. Jason wants to know, was the consent from the artist due to the suit from Pepsi and the band War?
Say that again?
There is consent. The consent from the artist, was that affected or based on the suit between Pepsi and the band War?
That's a very new case that came up just a few weeks ago. And from what I know about it, it's a result of exactly what I'm talking about. Mm-hmm. It appears from what I've read that while there may have been a deal done with the label, that for whatever reasons the artists are claiming that they were not bargained with prior to the use, and that there were no actual consent signed by them. So that case is an example of having done a deal with the label, but for whatever reasons these vocalists are alleging that no deal was done with them. So that is an example of a Section 28 case that's existing right now.
Great. Thank you.
So, Section 28, it applies to a principal performer whose performance is contained on a sound recording that is made under the jurisdiction of SAG or AFTRA. So what's a principal performer? Well, that's really anybody off camera who speaks or sings dialogue. So, that in this instance would be a solo singer. Where it gets a little bit interesting is with group singers. Group singers are defined essentially in the negative because the Section 28 excludes, for negotiation purposes, singers that are in an unidentifiable group. That distinction is very important since it's really not, it's all about whether or not we can get these deals done, and whether we can get these deals done in a timely fashion so that you can ship your materials and sleep at night knowing that all the rights were obtained. If the money is budgeted for and you have the money, then that's probably the most important thing. So what I'm saying here is that, if you don't have to negotiate and just have to pay the group singer, it's not an encumbrance to the deal, and worst case scenario, if that ball is dropped or we can't locate a singer or we didn't know about a particular singer, your commercial is going to stay on air. You're not going to get sued for failure to negotiate, but you'll get hit up with the amount that you should have paid had you known that the singer was there. So from a practical standpoint, it's a heck of a lot easier to deal with any claim involving a unidentifiable group singer than a solo singer who has the right to just put everything in stop mode, sue for whatever they want to, and get everybody crazy. The difficult part about the group singer is knowing when you are dealing with an identifiable group, or when you're dealing with a background singer or a group singer that you don't have to negotiate with. It's not clear from the contract, but from what I understand in the negotiations years ago that led to this, one of the examples that was discussed was, with an Aretha Franklin record with her backup singers, or Ray Charles record with his backup singers. It shows you how far back this was done, the Raylettes or whatever. And so that those singers actually would be in an identifiable group. that it didn't have to rise to the level of, 4 singers in a named group like the Monkees or the Beatles or whatever, but it could actually be sort of group singers that travel with and record with the group. What that leads us to believe is that, we're really talking about the studio singer who's brought in on a particular record to sing background vocals, and not anyone who is actually part of a named group, whether or not you know their name. Okay? And that can be very important because of the half a dozen or so Section 28 claims that we've dealt with in the past few years, many of them involve claims from singers whose names we don't know. Okay? So you can certainly be a principal performer, an identifiable singer, but we don't even know your name because you're one of 3 or 5 guys or women that were singing in this name group. Another key issue, another condition of triggering this right is that the sound recording had to have been made under the jurisdiction of the union. Unfortunately, this is not entirely clear in terms of whether that is a complete get-out-of-jail card, but I think for the most part it's understood that it is, as between the union and the industry. I'm not sure that plaintiffs' attorneys think that way, and I'm not sure that a court would ultimately rule that way for certain reasons that have to do with other provisions in the contract, but it's certainly something that we need to look at in the first instance. And it is something that I can tell you the agencies rely on, and I think that for practical purposes, if you get the right indemnities and warranties from a prominent label, then we could feel pretty safe relying on it. What it really means is that the employer, the record company, at the time the recording was made, had to have been a signatory to the AFTRA Phono Code. So if the record was made, as a union record, then it would apply. Some of us have this notion that if we're outside the country, we're okay. If we're inside the country, not okay. And I think that's generally a good rule of thumb because for the most part, records made by labels outside the country are not made under the AFTRA Phono Code, but it's certainly possible that a foreign company could be signatory. So it's, the inquiry doesn't stop with, is the label a foreign label? It has to drill down to whether or not that label was actually a signatory to the AFTRA Phono Code. So find this out. Find this out as early as possible because this is an extremely important bundle of rights that has to be dealt with. Can we push off this Section 28 obligation on the label? And again, for many years, we thought we could because you would have these master recording contracts that would say that they have the consent of the artist. But again, that's not this consent. That is that first side of consent, which is the consent of their personal rights and their performance rights. So what's happened is the master recording companies, the labels, all pretty much have similar variations on the same theme of contract, which is to have 2 provisions in the contract, one of which warrants and represents that label does have the requisite consents and permissions, including the consent of the artist, but you, ad agency, you licensee, are responsible for complying with any applicable union obligations. So there you have it. It's that bifurcated provision in the master that says, we'll stand up to the consent of the artist in the sense that they won't be able to claim that, they don't have, they've not given their right for the sound recording to be used. The earliest example of that I can recall is when Nike used the Beatles' Instant Karma, Revolution. I think it was Revolution. It was either Instant Karma Revolution in a Nike ad maybe 20 years ago, and they got all the rights that anybody would have thought would have been required, from Apple, I think at the time, before they changed their name or before the catalog move. And the Beatles sued and said, well, wait a minute, we don't endorse this product. And it was quickly resolved because the label had, the relationship that they needed. But that case didn't even raise Section 28 because the lawyers for the Beatles probably didn't even know about it. That was all about consent. So it is extremely important to button that up, but you will always have typically that second paragraph which will obligate the agency on the Section 28 claim. Now, this kind of begs the question of what if the agency or the licensee or the advertiser is not a signatory to the union contract? Where does that leave us? Are we free and clear of any of these obligations? And it's not entirely clear. I can tell you that on the AFM side of life, which is a very similar thing involving the obligation to pay musicians, the AFM has been sending out letters to non-signatory ad agency licensees saying, pay up. These are the musicians on your sound recording. You need to pay for the use. And the agencies are saying, why? We're not a signatory to any AFM contract. And the argument is that, well, these obligations of the record company for the new use that you're making have been passed on to you by contract. Essentially, that they are a third-party beneficiary of a contractual agreement between the label and the licensee to make these payments. So I could see the very same argument being made here, and I've seen this language, and I try my best to strike it or negotiate as much of it out as possible, but it's quite possible that if you look at the language in the slide that we're on now, like I finally actually turned to one of my slides, licensee warrants, represents, and agrees that licensee will obtain all requisite consents and permissions of applicable labor organizations, the copyright owners of the underlying composition, and others. Well, you know what? If you agree to that, you may have agreed to that. So that would possibly mean that you could have stepped into, if not unwittingly, then intentionally, who knows, the shoes of the record label by taking on those obligations. So clearly a best practice would be in the first instance to say, hey, don't put this language in this agreement because we don't even know what a union is. We don't even know how to comply with this and get it out. And it may be that the labels, because of extreme pressure by AFTRA to make sure that these contracts have these provisions, are going to tell you we have to keep it in. And then it's just a matter of your ability to deal with it or whatever risk tolerance level you have. So it's really best to get that out. Rob, any questions?
No, so far you seem to be crystal clear.
I didn't mean from you.
No questions from the audience either.
Okay. And I see that I'm really running really late because I'm only on the first topic. So I'll maybe skip through this. Just want to quickly go through the damages of Section 28, though. While the contract says that there are damages of 3 times the amount originally paid, which is really not a lot of money because you're talking about session payments, that is virtually never the case of what the artists are asking for. They have a right to go into court in lieu of accepting those damages and to seek whatever damages a court or actually an arbitrator would award. And just to get everybody even more concerned, the Flamingos were able to argue and get $250,000 per singer for 3 singers, based largely on evidence that showed the great importance to the advertiser of that soundtrack in the advertising. So, all of the internal documents that were saying how this is the record we need, this product won't sell without it, and we need it, we can't use anything else, was eventually held against it by establishing, a great amount of damages for each singer for violating Section 28. Had these singers been negotiated with initially, it could very well be the case that they would have accepted scale. Scale being for a modest media buy, maybe 20,000, 10,000, 15,000 each. Where we run into trouble typically is in negotiating with the vocalists, the artists, who are not getting any portion of the master fee. They're not a royalty participant, or they're disgruntled and they're fighting with the label. These are the people who, if we don't deal with them and they're watching TV and see for the first time that the music's being used, these are the people that we have the most trouble with. I'm going to jump ahead because we're, pretty short on time. I apologize for going through this so carefully, but I think I better, I'm getting the signal to jump ahead here to the next section, which is agreements with artists, which, more and more frequently this is happening. Advertisers, let's face it, the music industry is not what it once was. It's not doing too well, hasn't been doing too well for many years, and, what has been found is a great way to sort of reignite it and bolster it is to combine forces with advertising, and essentially to look at the advertisers, the major advertisers, as, I wouldn't say labels, but launching pads. If not for careers, then at least, as a kind of a synergistic thing to really push the artist and get that music out there. So clearly what was once something that was shunned is now embraced. So more and more, advertisers have developed relationships with established artists to create original music or remixes of pre-existing jingles. But the problem we had is that the labels, the publishers want their piece of the pie. So the first thing, probably the most important thing that you have to understand, that we have to understand, is that these artists will typically have exclusive relationships with their label or publisher such that they are not allowed to compose or write or record for a third party without their permission. So what that means is that the label and the publisher, mostly the label, I mean the publisher usually follows suit and the label takes the lead, but what it means is that the publisher is holding all the cards. That if you, approach, a hip-hop artist as an advertiser and get, start to talk and negotiate about doing a deal, maybe there's a tour sponsorship involved, kind of cross-promotion, all bets are off until you speak to the label, because this artist can't do anything without the label's permission. So the purest example of this is simply to approach an artist to create original music for an ad or for advertising materials. And so you really need to plan ahead from a budgetary standpoint and a clearance standpoint, because whatever amounts you might be discussing with the artist or the artist manager over drinks is just the starting point. Because it's not only about ownership and control and waivers, it's about the label, maybe wanting to recoup some money from the artist and get first dibs on that artist compensation. It's also about the label wanting its own fee for you to license what you own or actually don't own. I mean, it gets very upsetting because you think you're going to do a deal where you're going to own this music, then the label comes in, the label says, we're going to own it, and guess what? We're going to charge you for it. So, all of this needs to be thought through in terms of, this is our budget, this is all we got. Do you want to do this or do you not want to do this? And the do you want to do this side of it can be very powerful on behalf of the advertiser to the extent that this is good for the label. It's going to sell records. It's going to put this artist out there. So oftentimes we can have that leverage to get the artist and the label, particularly the label, on board, if they perceive this as something that is good for them. So, it's much easier to deal with when you're dealing with talent that's not yet established. You can get your work for hire agreement. You can pretty much do whatever you want and have a fair deal with the artist. Once you deal with the label, you're going to need to get those waivers. So knowing that the label will have control of this, the real first issue is, do you need to own the music outright? And more often than not, I think ownership, is just not worth it and not as important a thing as some agencies and advertisers think. Ownership is very important to the label, not entirely for exploitation reasons, but for control reasons. So that's a part of its catalog, and that if derivative works are made, that they have control over those derivative works, and it's really about their catalog and their ability to control their IP. The advertiser is really mostly concerned about exploiting that music in connection with its brand to the best that it can, whether or not it owns it. So I think, the best way to play ball is to just sort of deal with the labels, understand that they will want to own the music, that they may even want to have the artist create a long form that the label can, on its own, sell, and then just make sure from the agency and advertiser side that we have the rights that we need to use in whatever campaign we want to use it for. So that's paramount. That leads to the importance of getting all of the usage needs that are required by the advertiser. Skip ahead. Let's now deal with just some of the ways that these things can be structured. Best case scenario is that of course, music is owned by the advertiser, and all you really need is to get the waivers and releases, and it's best to make the artist responsible for securing and making payments for those waivers. Because, as I said earlier, a lot of times the label will want to take away the money from the artist because they might not be recouped. And so whatever deal you make with the artist may suffer and have to pay those monies over to the label. So, let's put that burden, if we can, on the artist to get those waivers, have them warrant and rep that. And again, this is something that if you're dealing with, Jay-Z, this could be a no-brainer. With like a Joe Schmo artist, it could certainly be a problem. The next best case is that we're responsible for obtaining the waivers and clearances with the label, with the artist's assistance. And that's more likely to be the case. Then in terms of the third situation is the one that we mostly deal with, and that's negotiating rights with the label and the publishing company. And once they get involved, it is also typical that whatever deal we've reached with the artist is actually has to be shown to the label, and they have to bless that deal. And then when the deal is done, the label will give you the same rights that the artist gave you in the label waiver. And that label waiver really becomes essentially a full-blown agreement, and with hopefully not too much of an expense. But as I said earlier, you would be best to leverage whatever relationship you have with the artist or our artist management to eliminate or keep the label fees down. One important thing here that I think is overlooked often is exclusivity in terms of some kind of a window where you don't want the label to steal your thunder. Let the ship sail. Let the campaign launch. Let the advertiser get out there and spend its money, its media dollars, getting this music out and associated with the brand. I mean, that's what we're paying for. We're paying for the ability to associate and connect to the brand. Let that happen without the label stealing our thunder and crossing up and marketing the record or a long form of this work by the artist, without our control. So it's real important to get a, whatever it is, 3 months, 6 months, 1 year, or whatever window, or it may be that from a marketing standpoint, it's beneficial to have the label simultaneously exploit the work. But it should be thought about and dealt with in the contract. Another issue that is a trap that we sometimes fall in is that sometimes there are proprietary lyrics or material that the agency or the advertiser will bring to the mix. Sometimes it's brought from a pre-existing phrase or proprietary phrase or trademark that the advertiser is already using. You know, it may be that a phrase like, you know, right here, right now is being used by an advertiser for some campaign, and they've developed some secondary meaning in it or association with the brand with that phrase, and then they go out and look for a song with that title to try to leverage it even more. And what happens then is that you have to make sure that there's a carve-out from ownership, from whatever label waiver or agreement you have or publishing agreement, so that when the music stops and you're no longer using the licensed content, you can continue to have rights in whatever proprietary music or proprietary words or phrases you brought to the relationship. So that's very important to think about and to have carved out of the agreements. Rob, we're getting close to the end. Any questions?
No questions thus far.
Okay. Anybody still listening?
Oh, yes. You've still got a whole room full of people here.
Okay. Different ways to structure agreements. You know, we could also think about barter arrangements with the labels. I did a deal recently that worked out very nicely because the label was interested in putting together a music video for a new song by a relatively new artist. And the deal we did was that the agency would create a commercial with the artist, and the label provided the music gratis for use in the commercial, and the agency gave portions of the footage from the commercial to the label to then use for a music video. So it was really kind of, a win-win for both sides. But what's important about that is, particularly from the agency side, the advertiser side, is to make sure that the proper warranties, reps, and indemnities are obtained in the agreement with the label with respect to the label's use of your footage. That might be footage that's produced under a union contract. There may be footage that you have limited rights to for other reasons. And we need to make sure that in allowing the label to use that footage, that we get the proper warranties, reps, and indemnities for their failure to use it only for the specific reason and rights that were given to them in that agreement. It's 5:03. I've got a very short time to wrap up and hit viral social media, my third section here, which really was mostly, if not only, about user-generated content, which is something that is not only what kids do and post on YouTube, but as of late, the past few years, it's been pretty commonplace for advertisers to reach out to consumers with music and actually allow the consumers to play around with it. To play DJ, amateur DJ, to be a mixer, recording artist, and to do their thing and fool around with it and create something and then upload it, either just on a sort of fan page on YouTube or Facebook, or as a part of a contest where there might be someone judging and saying, you win and this is what you win. And in these instances, and again, I don't really think I can get to this, but it's just very important that we start with the notion that the label is going to have very strict requirements about ownership of the user-generated content. It will have very strict guidelines about what can and can't be done in this user-generated content, and that means that on our side, on the agency advertiser side, we need to make sure that in the terms and conditions that we place on that point of entry for the user, that we follow the constraints and put that off on the user in the terms and conditions that they will have to agree to before they upload. It's very important to realize that it's hardly the case that an advertiser or an agency is going to go after a user for violating those terms. So it really is what we call the big whoop clause, because that's all that it really amounts to. So we have to just act with good faith. And I'll just end by saying that that can be done by putting out the proper terms and conditions about no this, no that, no samples, no vulgarity, no third-party rights without clearance. Make sure they agree to that. Monitor it, through a monitoring company. As soon as we see a problem, pull it off, because the label might require us to vet that. And then register with the DMCA, which, as many of you know, is something that maybe will give you a first bite, 2 bites of the apple, because it's a provision that if you register for, it allows for any third party to who believes that their rights have been infringed to provide notice, and if you pull the complaint about work down, you will not be held responsible. Okay, I kind of raced through the end there, but thank you very much. And if there's any questions and we have some time left, I'd be glad to answer any or all of them.
Great. Again, folks, if there are any questions, please go ahead and type them in. We'll use the last few minutes for questions. Many of you asked during the session if the slides would be available, and yes, we will be making those available to you all in a follow-up email after this session is over, so have no fear. You will get to get your hands on this deck. So let me just see any more questions out there before we let folks go. Oh, somebody said thank you.
You're welcome.
Yeah, that's yeah. If there are any further questions, as you see here on the deck, Howard's contact information is in there, so you can contact him directly. Yep, that's the only question I see right now.
All right.
We're coming up on 2:58. Thank you all very much. Please stay tuned for further PMA webinars. Watch the schedule. We're going to have more great stuff. And I know that we'll have another Davis & Gilbert webinar in December 9th. Topic to be announced, but you might want to mark your calendars for that as well. And we'll be doing something in the very near future around our Reggie Awards, which are starting in a couple weeks. So please stay tuned for that. Howard, thank you so much again for your time.
My pleasure.
All right. All right, everyone. Everybody back to work. Take care.